Yeah. Yeah, I think we should get started. Mariana just wants to make an announcement.
So this event is going to be live streaming to Brazil. FGV has now a master's in law and development, so the students are watching the workshop. I will ask people not to sit over there because sorry about that. And the video will be later available on a website, which is a brand new project that David and I and a few colleagues from Brazil are starting a network of law and development scholars. If you're interested in taking part of this, please contact one of us. And we are really pleased to have David here. Michael will make the formal introduction. Thank you.
Thank you, Mariana. And first I should recognize that Mariana has played the lead role in organizing this visit by Trubeck. It's hard to introduce David. In many ways, he doesn't need any introduction. He is truly one of the pioneers of the law and development movement. And of course, he's going to speak to probably the most famous or notorious paper ever written on law and development, almost 40 years ago, Scholars and Self-Estrangement, reflections 40 years later on what he got right, what he got wrong, and where we go from here. I think Buchanan is here. She's done a review of this paper looking at numbers of citations. I think she finds it's the most widely cited paper ever to have been written on law and development, even though on some people's views it pronounced the demise of law and development, which is kind of a bit depressing. That's what you have to do to get that. Get that wider circle of citation. David has spent most of his career at the University of Wisconsin from 1973 until just a few years ago. Now quasi-retired, but maintains a research relationship with Harvard Law School, in particular the Institute of Global Law and Policy at Harvard, and continues to write prolifically in law and development, comparative law, international law, and so on. But I will leave the introductions at that and ask David to defend, if he can, what he said 40 years ago in Scholars and Self-Estrangement.
Well, thank you very much, Michael and Mariana. And quero agradecer a presença dos meus amigos brasileiros em São Paulo. It's really a great opportunity. Mariana actually, and Michael and I were at a conference, and Mariana, I think, was the first one to suggest that we should look back because it is the 40th anniversary of this article. It is a paradox that this article, which was written basically about an internal crisis in a very small, nascent academic field in the United States 40 years ago, is still being widely cited, and Ruth's paper, which she wrote recently, counts at over 300 citations in the last decade. And as Michael says, the paradox is that it's an article, not only is it an article that was written to deal with what we perceived as a relatively specific contextual issue at the time, but also one that is highly critical of much of the work that had been done in this very new and, as it proved to be, very fragile field. One thing that's important to understand is the title, which was a little fancy and pretentious, but the self-estrangement is the key, because while this article is critical of the work of the field of law and development as it existed in the early 70s, the article was actually written in like 72, 73, we were among the people we were criticizing. That is, we were criticizing the work we had ourselves done, Galanter and I. Galanter had been very active in India, had written a very famous article on the modernization of law, which, when I started trying to think about this, was one of 4 or 5 articles that were of any relevance whatsoever to what we were trying to figure out. So when we speak of the critique, we're speaking of ourselves. Okay, so what I'm talking about is Law and Development 1.0. I'm sorry, the type is a little small, but I guess you can all read it. This was a very small part of the development, the overall development enterprise of the 1960s and early 70s. We had a law and development project in Brazil that I helped get started while I was an employee of the U.S. Foreign Aid Mission in Rio, and the budget was 1/740th of the annual budget of the mission that year, so you can get some sense of the magnitude of the law. It was small potatoes by the standards of development, and wasn't something that really got on the radar screen of the important people in the field, particularly the economists who were the guiding lights of law and development policy in the United States, and so on. The Ford Foundation was, on a percentage terms, more active, but in absolute terms, still a very small activity. So it's very important to understand, if we're looking at the history, how small this was as an actual development aid project. However, it was very big as a university project because the development agencies gave universities, was from the point of view of a university, a lot of money in the 60s and 70s. So there were major projects. And in the United States, the big centers were Yale, Stanford, Wisconsin, and Harvard. Yale, where I was at the time, received $1 million grant to be spent over 5 years. That's like getting $7 million today. And we wrote a 12-page double-spaced proposal with a 1-page budget. Those were the days of grantsmanship. I do more than that to get $5,000 these days. And there was a specialized center called the International Legal Center, which had been set up by the Ford Foundation and did nothing but fund law and development. So there was in this moment, in this period, let's say from the 1966 or 67 until the mid-70s, there was a sense of momentum. Things were moving ahead. We were going to be a big operation. We had big centers. We had lots of money. We trained people from all over the world. We brought in experts, social scientists, comparative lawyers, legal anthropologists to forge this field as an academic project related to the Development Assistance Program, which some of us had actually promoted while we were in the government or in the foundations. By 1975, the field had sort of started to lose momentum, and that loss of momentum coincided with the appearance of scholars in self-estrangement, and so people pointed to this article, which has a very critical tone. Unfortunately, the critique part of the article is much more powerful and clear than the reform and reconstruction part, which we thought was its purpose. We thought it was an article to reform and reconstruct the field, but we kind of skimped a little on that part of the discussion. So, in order to understand what the critique was, you have to understand the ideas. And I've tried to summarize them very quickly. Of course, the whole thing was built around two ideas that were very dominant at the time: modernization theory and stages of growth. So there was this idea that society moved from traditional to modern, and that countries went through stages of growth, and this had a kind of neo-evolutionary, teleological thrust to it that influenced our thinking to no small degree. And of course, since we were able to look at the developing world in general and see it as not quite modern, it therefore, by definition, had not quite modern law, and that we decided must be an obstacle to growth because you needed modern law if you were going to be a modern country. We believed that law could be a tool for modernization by equipping at strengthening the capacity of governments. This was a time of state-led development, equipping extending their capacities. And we thought that a modern law could be imported, that after all, if you need what you needed to have modernization was modern law. This sounds like a parody, but unfortunately it isn't. Then you just would go to where they had modern law. So, you know, Toronto, you have a lot of modern law here. It looks pretty modern. We had it in, you know, New York or wherever, California. So we would just wrap it up and put it in a box and put it in a boat or maybe in a plane because it was small, and that's what we'd have. And we spent a lot of time doing that, bringing these various legal instruments, copying that. Another and very important part of the original law and development idea I describe as legal reform is liberal reform. That is, if you improve and modernize a legal system in a developing country, this is a move to support what I would call in very general terms liberal values, freedom of speech, due process, equal protection, all of those sort of core values of liberal legalism. We assumed that they were inherent in the DNA of a legal system, and therefore if the legal system was stronger and more modern, it would be more liberal. And finally, we thought that you could change the world of law in these countries by reforming legal education, because you would train the new modern lawyers who would go out and construct the modern legal system. So the leverage would be found in the law schools, and that's why if you look at a study of the number of projects, the type of projects, you'll find legal education reform figuring very prominently in the story. Well, obviously the critics, and by the critics I don't mean just Mark Olander and myself, there was a sort of reaction in the academy that came from many sources. To some degree it was inspired by our students who were reacting to the stories we were telling at a time when there was tremendous turmoil in the American academy. This was the period of the protest against the war in Vietnam, generational conflict of tremendous significance. I said that I thought when I went and left, turned down a job at an elite corporate firm in New York to go work for the United States government in Latin America, that I was doing some bold, liberal, left-wing, progressive thing like joining the international brigades in the Spanish Civil War. And when I got back, my students treated me like I'd been in the SS. No kidding. So we went through a pretty searing experience, those of us who sort of started, in trying to teach this in law schools of the late 60s and early 70s, because the students were fascinated with the subject, but their point of view was, get out of the third world, American pigs, you're just a bunch of imperialists. So we had to sort of modify the story a little bit. We didn't give up, and we didn't accept it, but we recognized that we may have made a few minor mistakes. So what did the and so I want to say that the critics were not just us, although, and I think the significance of the article was that it picked up not just an individual or critique of two people, but caught a moment in the field and was well accepted by large numbers of people at the time. So we rejected the kind of neo-evolutionary implications of some of the literature. And particularly Mark, who had already had spent a lot of time studying the Indian legal system. He was a real comparative lawyer and was at the time working on what turned out to be a very famous article, a book about the law protecting untouchables. You know, he, more than I, stressed the fact that the local legal systems were deeply embedded in local conditions, and the idea that you could easily transplant modern law was, you know, just naive. I added the fear that some of our reforms that we carried out in Brazil to strengthen legal education and make legal education more effective and instrumental could be serving the cause of what was at that time an authoritarian military government, and therefore the idea that legal reform was necessarily liberal reform seemed a bit naive. We doubted the efficacy of the education first strategy, wondering whether you could really change law schools if the profession didn't want them to be changed and didn't demand a new kind of education. We feared the pull of the policy audience, that is, we feared that we were being too much influenced by what the agencies were doing and that we should get some distance from the agencies, and we recognized that we had sort of leaped into this with a bunch of preconceived ideas without really any adequate theory or any empirical data of any real validity. And the point I want to stress that because it's part of the story, there was nothing there. There was no field of law and development. There were no senior people who studied this, at least in the United States. There were we were not trained to do this kind of work. Those of us, most of us who came into this field and initially were lawyers and who had been given a sort of standard American liberal education of the 60s and early 70s, which equipped us to be, you know, successful corporate lawyers and cynical government bureaucrats, but not to do research on remote legal systems and foreign languages and doing empirical studies. And this was a time in which, you know, law and society type work was not being done in any law schools in the United States, or just beginning to be done. The Law and Society Association having been formed in the United States in 1964. So we were ill-equipped, and yet, of course, this started as engagement in reform, not just as an academic project. Okay, so the big debate was over what caused the decline of the field, because the field did decline. It didn't die completely, but it really declined from what appeared to be a high moment, a moment of growth. And there are really two parts of the story. There was no base in the academy, and at the same time, the agencies cut their funding. So we found that this field, the robustness and the energy in the field had been driven much more by the soft money than we thought. And when the soft money was gone, and the wave of enthusiasm in the development agency world had receded, we were left on the beach. Yet we had not really built the base in the academy. There were no people with senior status in the field. There were no texts. I mean, for a totally devastating critique to become a canonical text is a story of a field in some trouble, one might think. As I said, we had very little training. We weren't able to produce the kind of crisp and authoritative scholarship with grand theoretical pretensions that was expected by the law schools of the time, because we were just feeling our ways. It was a bootstrapping activity, and as I mentioned, the students were hostile. I won't go over why the agencies cut their funding. It's in the paper. The basic story is there never was much support in USAID. It was a few lawyers like myself and some of my colleagues who convinced AID to put some money in. It was a tiny amount by aid standards, but huge by university standards at the time. And when those people moved on or lost their positions of power, it all changed. Ford is another story. And the International Legal Center, which we thought was going to be the beginning of a giant move, turned out to be the end of Ford's involvement. They were just doing this to sort of close down the shop, turn it over to this small entity which they gave some limited money to, which was eventually spent down. So that's the story. So as I say in the paper, Mark and I's response to the you killed the field claim was we plead in the alternative, it didn't die, and if it did, we didn't do it. All right, so let's move to the closer to the present. So I'm going to go over this very quickly because those of you, at least many of you probably know, part of the story of the revival of the field. I believe that the main reason that the field of law and development revived, and it did very dramatically, both in terms of scholarship and in terms of programmatic activity by development agencies, I believe that the main thing that happened were that the economists discovered the importance of law. And this was, something that had not existed in the early days. The lawyers discovered the importance of law, but nobody paid too much attention to them. But when the economists started saying, well, law is really important, the World Bank started listening, and all the development agencies also sort of went along. That, to me, it's a simple-minded explanation, but I think that it's very important to see that because the lawyers were not successful until the economists picked up the ball and ran with it. The economists discovered law because of the move to markets, both in, of course, to replace the Soviet command type systems that collapsed in the early 90s, but also to liberalize the more dirigist, centralized developmental states like Brazil, which were also, it was also thought that the excessive degree of state involvement was impeding development, causing all sorts of distortions, and that what was needed was to create, liberalize the economy, reduce the role of the state, and create the framework for market activity. The economists believed that, and therefore they eventually realized that law doesn't make itself, and legal systems don't just come out of nowhere, that it's an actual intervention that's required, and that led to a lot of support. And then, rather than being legal education centered as the early development assistance programs were, this, what I call Law and Development 2.0, was more broad-based. That is, there was a recognition that if you're going to transform a legal system, you have to work at all parts of it, not just legal education. But there was a priority for the judiciary. I think if you look at the projects, if you look at, and I've never done this in any systematic way, and somebody should. If you try to look at where the money went, I am certain that you'd find that by far the largest single investment from the various development agencies, the World Bank, the regional banks, foundations, bilateral agencies like USAID and the European equivalent, went into judicial reform. And I've written about that, so I won't bore you, but the short answer is that the judiciary served two purposes. First, they would craft and develop the legal institutions and manage and implement the legal institutions needed for markets. And secondly, they would serve as a barrier to excessive state intervention. So judiciaries became central to this market-oriented move, and it became big business. I mean, billions and billions of dollars went into it. Okay. So at this time, I don't want to say as a result, but at this time, by which I mean, shall we say, the early to mid-90s, academic work in North American universities on law and development revived and became a much more important phenomenon. I don't want to call it a field because that's one of the issues in the discussion, but a much more important in practical terms number of people, articles, research, studies, whatever. Of course, this was stimulated by the surge of development assistance. There's no question about it, and by the restructuring, the broader restructuring activities that were related to the sort of neoliberal push of the 90s, which involved many different things, including, and I think this is very important, the increased importance of trade law as a factor in domestic legal institutions as a result of the Uruguay round. So we had more academic work, but unlike the earlier period, the academic work was stimulated but not dominated by the academy, not dominated by the agencies. Why is that? I think that, and here the article goes into some length to discuss it, it really has to do with what was happening in universities in the interim. That in the period between the 1960s when we started this and the 1990s when the field began to revive and flourish, I don't want to say that the work on law in developing countries in the North as well as in the South, but I'm focusing now for the moment on the North, the universities in the North had become much more sophisticated. First place, what I would call the law and society idea that you need to study law in action and not just on the books. You need to use various techniques of the social sciences, both analytic, as in, say, law and economics, or empirical, which is more the law and society tradition. All those ideas had already, been accepted for domestic study of law. And critical traditions had emerged, as well as sort of movements that are tied to certain values, gender, human rights, environment, so on and so forth. And these sort of separate dimensions, active in the universities in the North, could glom onto issues now in the South and relate to those in a way that was much more sophisticated and developed. And meanwhile, there's more sophistication in the South and more interchange as universities in the South began to themselves take on greater capacity and people who were more educated to these traditions. So it was a richer world, and so it was not, and the schools had more money and people had more research resources, so there was less complete dependence on the outside. So that's the good news. And that, I think, is why the field revived. But it didn't become dominated by agency ideas. The agencies also, I think, were a little less certain about what they were about. Not that they had learned all the lessons, not that they, were completely chastened by the critiques, far from it, but at least on the fringes there was a recognition that maybe the ideas that had animated the sort of modern law export project weren't completely and totally convincing, and so there was even a little maneuver in that. But the universities were strong enough and rich enough intellectually, not so rich financially, but rich enough at least to sustain activities, so that we had a new base and a much more encouraging base. Now, so then, as I try to look forward from that revival, I'm looking at the things I think that are the important influences that are shaping the field now. And again, field in quotes, please, because the question of what is a field and whether we have one is, to me, the most problematic question today. So I see four major influences. One I call the new humility. There was a lot of work in the early 21st century to review what had happened in the past and take on some of the lessons, including the lessons of failures. And I think that that both gave a more open-minded approach to the academic world and some more open-mindedness in some parts of the development world. Although when I gave this talk to people who are more engaged in day-to-day development work today than I am, they were a little skeptical about how open-minded some of the agencies are. But I think, at least compared to the past, there is some new humility. And this is particularly about the export, the whole transplant business, which has been roundly criticized. Globalization, the second major influence, changes the frame. As you move to open economies with export opportunities and import, which sort of implies a certain degree of import openness, then global competitiveness becomes an important factor in development policy, and this shapes a lot of things that have been occurring. And then, of course, you have transnational law, of which the WTO is the most obvious, but there are other transnational legal influences now becoming much more important in the domestic life of the law in many countries. Of course, you see a return of the state, the East Asian miracle, and the success, at least until recently, of the BRICS, all which are, to one degree or another, have a significant investment of, the state is a significant player in development, also changes the frame, as does the rise of what I call the new developmentalism, which I'm going to talk about a little bit, because I think that's very important. And I'm sorry, this slide is, if I'd known, I should have had more type. But so the new developmentalism, which is discussed in a book that I was a co-editor of, and which is also discussed in the latest issue of the World Bank Legal Review, for those of you who want to follow up on this, what are the big elements of it? Okay, open economy, export-led growth, import competition, no single model. While in the past, both in Law and Development 1.0 and Law and Development 2.0, there were single models that were pushed very heavily and supported by the development studies world. Today, at least, some part of that world recognizes that there is no single model, that innovation and local experimentation are essential for countries to find their place in the world economy and to experiment with ways to integrate the social and the economic, and therefore that there's no single model that can be dictated to developing countries. Industrial policy, at least in new form, is back and is accepted more as more legitimate, but often tied to the idea that there ought to be robust public-private partnerships. The new developmentalism stresses the importance of the social. It's not economic development, it's social and economic, and to some degree political development. And so it's important that this be brought to the center of the enterprise, not just on the periphery. And finally, that the social and social policy and industrial policy should work together in a kind of synergistic way. Those are very, very superficial summaries of a very complicated body of ideas. But they lead to some new roles, not to eliminate many of the standard work in law that needs to be done and has been well charted by Michael and his colleagues in several volumes and by many people, but these are sort of additional roles that come from some of these new approaches and new ideas. The idea of capabilities, which you're all familiar with, the need to provide a legal framework for new forms of social policy, to orchestrate experimentation in industry, to provide legal tools that will allow government and industry to work together in an experimental way rather than in the kind of fixed top-down manner that a lot of the old developmental state used, and that includes facilitating public-private partnerships. There's a need to coordinate multiple agency activities because you're dealing with the integration of foreign policy and domestic policy because of the importance of trade in the policy mix, which itself involves engagement with the WTO and so on, but also integrating the economic agencies with the social agencies, and then of course the need to harmonize domestic law and international law. So these are not, these are all new, they're not brand new, and all this has happened in the past, but the new developmentalism puts more of an emphasis on it. Now, okay, so I'm coming to it. Yeah, good. Okay, coming to it. So, I think that as I've thought about this, and now sort of trying to pull together a lot that's happened and a lot of what I've tried to summarize, I come to what I think is probably the most important part of this paper, which is, I made very clear, a very preliminary document, the start of a project, not the report of something completed. And I think that if I have one takeaway for you that I would hope you'd take away from this, other than that I didn't kill law development, which was important, and that is that the importance of context in the search for usable knowledge. If we think, as I do, that the purpose of a field or a network or a thing of law and development is to produce usable knowledge that can be helpful, that will allow developing countries to advance their goals, whatever they are, that this knowledge has to be contextual. That grand scripts of world historical processes of the modernization and stages of growth, or capitalism, socialism, communism, or any of these sort of meta-narratives are not particularly useful in the end, although they may be useful in helping to formulate questions. Context is important because the new developmentalism is fostering policy variation, not one size fits all. So that to the extent you want to understand what a legal system can do or to further or is impeding the developmental agenda in any country at any time, you have to look locally because there won't be one system that's being implemented. Secondly, and this is the lesson of the early period, and we continue to remind people, you must continue to remind people, is because of the embeddedness of legal systems, whatever is happening has to be seen in its embedded operation, because generalizations across countries or across regions or across legal families, like common law and civil law, are just simply not useful for the end result, which is to produce usable knowledge that can help people in particular countries in particular ways. And context is important because as law and development has become more complex and has now, there are many different takes and many different perspectives. There's human rights in development, there's gender in development, there's trade in development, there's environment in development, and so on and so forth. All of these are very important, but they have to come together at some point to assess specific moves and specific experiences in specific places. And again, context is important. So if you believe what I've just said, that is that the learning of the past 40 years and the new ideas of the current decade point us toward contextual knowledge as being what it should be the goal, then it seems to me that there are 4 things that we need to take account of. Of course, this knowledge must be theoretically formulated. You just don't go in and say, you know, what's going on, and framed interdisciplinarily, because law and development is an interdisciplinary idea that needs to be worked out. You have to think through what it is you are trying to do in a way that integrates the legal institutions with developmental goals, whatever they may be. It must be evidence-based, and therefore research has to be done on the ground. It should be locally focused, but horizontally informed. Horizontally informed means by looking not at the legal systems of France, Germany, or the United States necessarily, but looking at similar countries in similar conditions to learn from your peers. And the whole idea of horizontal coordination and horizontal, I've written about that, and I don't have time to go into it, but I think it's very important. And holistic, I've already mentioned that. That is, you've got to look at all the dimensions that have sprung up in this proliferation of subfields in law and development. And that brings me to my last point. So the good news is that the field, if you define law and development as research on law and legal institutions in developing countries, being done either by people there or by people in the North or jointly, then we can say there's a very, very positive story. There are many different sub-things, I say things because, but I'm going to call them sub-networks. There's a law and economics sub-network. There's a women's rights and gender sub-network. There's a very active human rights and development sub-network. These networks are often constructed in a north-south way. That is, they're constructed across this geographic boundary and engage people in the north and the south. Often the people in the South who have studied in northern universities and then maintain their ties. Of course, there is what I call topic proliferation, and there are silos, because these sub-areas tend to be siloized. That is, the law and trade law people don't talk to financial law people, even within the economic category, and certainly don't talk to people who are concerned about gender issues or climate change. So there are these I call them north-south silos, or even academic commodity chains. And that's what the field looks like today. And they don't talk to each other. That's one reason why it's difficult to call it a field. There's also disciplinary fragmentation. You see the economists, or a lot of economists, taking very different approaches and coming out with very different practical conclusions. And I talk about that in the work of Katharina Pistor in that context. She's tried to challenge some of those simplifications. You have a disciplinary divide, you have a topical divide, you have the north-south relationship, which is not always very well structured. You have the weakness of the relative weakness of universities in the South. Some are really quite strong and interdisciplinary and globally connected and horizontally linked, but not many, not enough, and not even those who aren't to the extent that would be optimally desirable if we're to produce usable knowledge for their particular countries. there's too little South-South cooperation, and there's nothing that remotely looks like a field. If a field means a canon, journals, associations, meetings, none of that exists. Ruth Buchanan suggested that to define the field, we would simply include all the people who have ever cited scholars in self-estrangement, whether they loved it or hated it, and that would be a field. Well, I hope we can do better than that, but it might be a start. Thank you very much.
Okay, I will keep the list. Who's up first? Ed, David, Mariana, sorry? Rowan. I've already written these down. You remember, right? Evan. I called you first, Ed.
So, I guess I'm wondering. So there's the first time around there was these grand theories and sort of broad strokes that we can sort of solve these problems with some grand theory, and then that as you document and chronicle nicely leads to problems because actually one size doesn't fit all, and so we've been getting more and more sophisticated historians, I think, terrific on this, showing how important local conditions are to understanding how various legal reforms might or might not work. And that sounds intellectually, much more sophisticated and much more plausible. But then I despair about the project for the separate reason, which is you just end up with a bunch of observations about local phenomena from which it's very difficult to generalize. You spoke about horizontal comparisons as best you can, but you can't use common versus common, that's too crude, but no matter what you do, there's going to be some argument that you're introducing some crudeness in as soon as you start to try to generalize and form hypotheses across locations. So, I mean, Michael and I have had sorts of exchanges about this over the years where the concern would be, now that the field's gotten so good, actually, we've learned that we can't generate any lessons. And to what extent is that a kind of concern, and how do you deal with it?
I wrote down the word despair. That's a very good question. Well, maybe I've overemphasized the context and underemphasized how you get there, because I believe that context-dependent research starts with some kind of general knowledge about what questions to ask, what answers make sense, what possibilities exist, but you must then get to the point of the spear, which is the local context. So I'm not arguing for just mindless pragmatism. I think that there are some, broad questions that can be used to frame, but not to answer questions. So I said theoretically formulated, but evidence-based and locally focused. So I'm trying to, work out something that recognizes there are no clear universal answers that you can immediately act on, but there may be general ideas that are worth looking into. I guess that's the way I'd answer it. So I cross out despair.
Who did I have next? David, I think.
Yes. So I'm sure you have examples of contextual knowledge and policy variation being put into play, but I want to press you on the prevalence of contextualism in this new developmentalist framework in which we live, or era. And I want to sort of challenge the hypothesis by pointing to the rise of China. So China appears to be a major player in the field, and its aid and investment is welcome, right? Or it was welcome in many parts of the world. It's being challenged, I think, now and questioned. But for some period of time, China's been more welcome as a source of aid and development than any of the typical northern states, and it's been welcome on the premise that there are less conditions attached to that investment. So I wonder if that's a counterfactual to the hypothesis that there was a lot of policy variation and textualism.
First, let me make very clear that at this point, what I'm talking about is the academic field, not the policy world. So I think that the academic field has recognized I don't even want to say that. I think there are people in the academic field, and there are trends that can be pointed to that say people are more aware of this modified contextualism, okay? I take that as a friendly amendment. And the modified contextualism. I cannot say that development agencies have all fallen in line, and indeed when I talked to Steve Golub, I don't know if you know who he is, but he does a lot of work with UNDP and the World Bank and so on, and last week, and he said, Dave, you haven't been in the field for a while. So I want to be very cautious about that. Now, so what you're really suggesting, now I see what, I now think I see what the question is. The question is, if the agencies were as flexible and as contextually sophisticated as I'm saying, why should the countries prefer China to the World Bank or to USAID? And the answer is, they're not that far, they're not there yet. Nor maybe should they be. In other words, I'm not going to say that China's the solution. That the Chinese model, which has, which technically has no strings, but has real strings, but they're not those kinds of strings. So I guess the answer is that it does show that countries sometimes will welcome Chinese investment because there's less conditionality, but not the kind of conditionality that the law and development people are concerned about. They're not concerned because someone's telling them they have to reform their judiciary. They're telling them they have to totally restructure their state and eliminate their budget deficit and fire half the corrupt officials and do all sorts of other things that aren't so easy to do. So that's my answer.
Mariana?
So I have two questions. The first one is, how insulated are we, the academic field, from the development agencies? And I think the context here is that on Line Development 1.0, you basically show that the field was paid by the agencies, and in the 2.0 version, that's no longer true. So therefore, there would be some form of financial independence that could assure us that we are on more solid grounds right now, right? But the thought experiment that I would like to pose is the following. We may be financially independent, but we do have an object of study just because the World Bank is doing this right now, right? But the BRICS has just announced the creation of a new development bank that's being called the BRICS Bank. And if the BRICS Bank starts adopting what China has been doing in Africa, which is no strings attached, no governance concerns, the World Bank may just follow suit, and then we may be left without an object of study, right? So that would be a pretty bleak picture for us, and I was wondering if you have a more hopeful outlook of that, of the fact that it could survive even if the development agencies stop engaging with this kind of institutional governance policies. The second question relates to your very positive view of the possibility of reducing the fragmentation in the field. And here, I think my question is, how do you see that overcoming divisions across disciplines? So how do you see the anthropologists analyzing rule of law reforms in Africa talking to the economists? Or even to be a little bit more concrete, within a law school, how do you see the CLS people talking to the law and economics people regarding law and development reforms? So these are the two questions.
Well, these are small questions. Oh, I don't think that, well, this is, it never occurred to me, but this is kind of the same question in part. Your first question in part is similar to what David was asking, but it's, instead of the Chinese, now we've got the BRICS who are screwing up the conditionality business, right? That's what's happening, right? Well, first place, of course, we don't know if that's going to amount to anything. That's the first question. But let's assume it does. It's not clear that they will have quite the same lack of conditionality. I think that they will encourage things that are closer to their model to the extent that they share a model. And of course, as you know, there are many vast differences, but there are some similarities. They all are state-led. There's a major state role in the economy compared to the, you know, the sort of neoliberal ideologies. Obviously, it's unlikely they will get down to the specifics of legal reform the way, say, the World Bank has. But I doubt that that will lead to a change, a major transformation. And here's an important point to recognize, and you know this as well as I do. The World Bank's influence is as much an influence of ideas as it is an influence of money. Don't forget, the World Bank spends 1/3 of what the Brazilian National Development Bank spent last year. So in terms of actual financing, it is not such a big player as it was at one time relative to the rest of the world. So I don't see that these things are going to make the sort of model, make the agencies transform their ideas in a way to sort of, you know, just say whatever, you know, you want some money this year, go do what you want. I don't see that happening. So that's my answer to that. Now fragmentation, that's closer to my own personal experience, as you know. So I think this is a big problem. So I mean, I see this in, I can imagine a law school in the global south where there are people who have been influenced by various critical traditions, whether you want to call it CLS or something else, critical race theory, whatever, and people who are influenced more by law and economics, who don't talk to each other, but they do talk to the people in the north. And that's part of the siloization that worries me, because if there's some value to critique and some value to law and economics, both of which I think are valuable, it is because they will, if, you know, through some form of debate and discussion, hopefully refine and improve ideas that will ultimately be of use, of practical use. That's my view about the need for debate and divergence in the academy is that this is important, but it's important because in the end it brings, it should bring better knowledge. Now, if everybody just sits there and talks to each other or to the people in some other country, whether it's north or south, that agrees with them, then all we're going to do is have a lot of silos. So the plea, the only answer is to try to convince people that if what they want to do is actually contribute to the development of the country, or a country that they're working with if they're from the north, they just have to stop, you know, living only in talking to the converted, and talk to the other people as well, or it's just an academic game. And of course, a lot of it is just an academic game, and that's the problem. But I think that I think the people who do this work are not just you know, careerists trying to move ahead in a hierarchy. They're all careerists. We are all careerists trying to move ahead or survive. We may not move ahead, but survive in hierarchies and workplaces that are, you know, very competitive and contested. But also, nobody, you know, you don't go into law and development to make a lot of money. And mostly people are, you know, really have some sense that they do want to see improvement in the lives of people in the country. So a plea of that kind properly made and institutional arrangements that facilitate some discussion could possibly bridge these gaps. But would it be easy? Absolutely not. I spent 10 years trying to get CLS people in the United States to talk to Law and Society people in the United States. And it's been about as successful as the Arab-Israeli negotiations. So I can write despair back again? I don't know. So,
Rowan, is it right?
Yes.
You're on.
So you're advocating for, against a one-size-fits-all approach to development. And my question is whether you would advocate the same thing with respect to goals of development. On page 27, you cite Sen and other scholars and say that the ends of development is human dignity and liberty, based on my reading of the article. And my question is, do you think that the goal should always be human dignity and liberty, regardless of the custom and cultural traditions of a given country?
yes. It's kind of hard to be against human dignity and liberty. Now, what that means in a particular context, I can play the context-dependent card now. But of course, I don't want to challenge, you know, the people's definition of human dignity. So there's a relativistic implication here that would save me from the accusation of liberal imperialism, I hope. Is that the answer you wanted or you didn't want?
No, it's
But what I do want to say is that it's a proliferation of different takes on development, which includes the kind of perspective you're suggesting, that I think is important in order to have in order for the field and to produce useful knowledge. So
maybe I could reframe Rowan's question a bit, because I struggled a bit with this too. If you adopt Sen's view of the ends of development, development is freedom, and his definition of what freedom entails, and one could crudely describe this as kind of egalitarian liberalism.
Mm.
So does every developing country in the world have to espouse that as its conception of development? We can think of many developing countries that don't, for cultural or religious reasons or whatever.
Well, I think that human dignity is, I would have to go and sort of look at some detail, but I guess that this is a big problem. And I don't want to sound like we're imposing one-size-fits-all moral values, but I think that the idea of human dignity it could be a topoi for a discussion among people of different religions, different traditions, and there may be different ways to define it, and but I think that the very words, it's just hard to imagine people embracing the opposite of human dignity, suppressing human dignity. I don't know that there's any tradition that says our purpose is to suppress human dignity. Now, there are a lot of traditions that some people will say are suppressing human dignity, and then you've got a very complex and very difficult argument to be made, but it's an argument to be made. So that's kind of the way I handle that.
Evan, Carrie, Lindsay, am I missing somebody?
Yeah.
My name's Aaron.
Aaron. So Evan, you're on.
So one of the one of the key, I guess, features of the developing law and development, I guess, or 21st century law and development that you see as necessary is sort of a theoretical basis, is what I'm gathering. And in the paper, it seems like you're hanging your hat on varieties of capitalism to do a lot of this work, particularly as a, am I misreading that?
Go ahead.
And I have some concerns about this, because I agree Pistor's done some work on this, and there's definitely a lot to commend the theory, particularly in the getting rid of the idea of the one-size-fits-all. But at its core, it's a theory that says that there are two ways to get to development rather than one. And if you're looking for anything beyond the idea that there's not just one way, you're still left a little theoretically barren within that. I'm just wondering if I'm misreading this at all.
Well, actually, my own thinking about this has not really been influenced in a very profound way by the varieties of capitalism literature. I think that is an actual important influence in some people, and actually it was a reader of the early draft that suggested adding that. My own view comes more from the experimentalism, innovation, Roderick Sable line of thinking about bootstrapping, innovation, searching for niches in the economic sphere than it does from the varieties of capitalism. But of course it implies the same thing, because it sort of suggests that there are a wide variety of possible models of a essentially market economy, not necessarily just binary, but multiple. So I come at it more from that side than from varieties of capitalism, which I just think is a kind of piece of evidence to support the argument that I had reached using other lines of inquiry.
Carrie.
Yeah. Let me come back to the issue of the field for a moment. Just a comment and then maybe a question. I myself don't think there's any reason to worry about the deep fragmentation along disciplinary lines or even within them. The proliferation of lots of different methods, lots of different ways to look at and think about law development. Arguably, that's a sign of the health of the discipline rather than a problem within it. So, I mean, we could say the same thing about contract law, we could say the same thing about process. But it doesn't strike me that that's really a threat to the field at all. There's another axis of difference, though, which maybe does pose some deeper questions, and that is the conception of development. If it is the conception of development itself, what we're talking about when we're talking about development. If you're right, and let's assume that you're right, that at this particular moment in time, we have a conception of development that isn't limited to economic growth, that incorporates a much broader set of social and other goals. And let's imagine further that the ways that those social goals might be conceptualized is also quite plural and quite contestable. In fact, we're not really sure what the limits are. And it strikes me that that's potentially a deeper sense of instability, or creates a deeper sense of instability to the field, because we don't necessarily agree on what the object might be, and at least we have to keep open the possibility that it might be conceptualized in radically different ways in different contexts. So does that sound right? Or in fact, does the field depend on some agreement about the concept of development as well? And if that's true, do you want to specify what you think?
Yes, I have here a definition of development brought to the table. No, I think that the one thing that I would disagree with you about in terms of formulas is that I think that the very debate about what is development is one of the issues that I want to see happening, but in order to do that, the fragmentation that I'm describing is as much about that as it is about some other factors. that is different views of what is development is also built into the fragmentation in the silos. And so what I want to see is arguments among people about that. I don't think there is a thing called development, but I think there are arguments about what it might or ought to be, and that's what the field should be promoting. Because I don't think there's some magic definition that you can get from Roberto Unger's latest book or someplace else that's going to tell you, okay, that's it, that's development, now we're all set, and so we'll just work out the details. No, I think it's a debate. The debate about what it is or should be is indeed what the field could contribute more than any single thing. But if the different people who have different perspectives and look at different dimensions don't talk to each other, then that debate won't happen.
David, how do you avoid the charge by H.W. Arndt in his little book, the Economic Development, the History of India, where he says that development becomes just everybody's idea of utopia?
It's something to be avoided. Okay, all right.
I mean, this is a tough charge to meet, isn't it?
It's a tough charge to meet, but again, if at the end you have to produce usable knowledge, one thinks that brings you down to a more realistic, or as my colleague Eric Olin Wright teaches a seminar called Real Utopias. Right? So maybe development is driven by real utopias, that is sort of visions that you have to then test against reality to see if they are possible. So I guess there's some kind of, in my mind, and this is a very, really challenging question, there's some reality test down the pike that will perhaps impede people from flying off into unreal utopias.
Gary?
Just isn't another possibility, though, and one that I think there's some evidence of, is that in fact to stabilize the field, what you actually get is a consolidation on particular markers of development. So that to make the field not fly off into outer space, we do fix on markers like, or the numbers of girls in primary school. So that strikes me as a more likely possibility and one that's got more problematic possibilities.
Indicators.
Exactly.
Well, we could go on about indicators for hours, so I don't want to go down that indicator rabbit hole. But indicators are both a possible way to solve some of these problems and a potential trap. And I think that's as far as I want to go on indicators, unless people want to follow.
Lindsay?
Well, sort of tying into two of the threads that I've heard voiced throughout this, one on the side of sort of, well, how generalizable are any findings from individual case studies versus, you said, sort of the indicator-based model, which are usually these large-scale quantitative analysis models. And then also the, what is development and the challenges that poses. And I was just wondering if one path you might see going forward for law and development as a discipline or a field or whatever other meaningless and meaning-packed term we can give it to it, is that once we establish that there's a policy objective, whether that is, you call that economic growth, whether you say sustainable economic growth, or sustainable broad-based economic growth, all of these types of things, is sort of a goal of the law and development field, or do you think it should be a goal of the field to try and figure out how can law promote these objectives and or present obstacles to them? And then to the extent that we can use these either case studies or large-scale quantitative mechanisms to identify what are the factors that make these types of outcomes more or less likely in terms of legal reform efforts.
Well, okay. Now we're talking about indicators.
Well, we're talking about...
No. We need to talk about indicators because you can't want to. Well, but she then, I said, unless somebody else raises it, whether you meant to or not, you've just raised it. So now I got to know what indicators. Okay, I think indicators are, indicators, I'm not against indicators. I think indicators are very important to help us refine what it is that we think development means, and debates about indicators are themselves part of the kind of debates I'd like to see. What I'm very nervous about, in fact, but I am very sensitive to how difficult it is to develop indicators and how bad some of the indicators currently being used are. And often they are created for what I would think is, partisan purposes. That is, the indicator, you take the indicator that measures what you want the conclusion to be. What I'm nervous about is using large, big data correlations. That is, it's one thing to say, let's say that the number of girls in primary school is an important goal, right? We don't have to argue about that. We can accept that or not accept it, but then you can count the number of girls in primary schools. What makes me nervous is we get these indicators of macro statistics, growth, per capita GNP, even human development, the HDI indicators that go well beyond the economic. And then somebody says that if you correlate that, you can see that if you have 14 judges instead of 12 judges, then you're going to get more. And I've seen graphs that the World Bank has put out where they correlate economic growth with ROL variables. So the more ROL, the more growth. Now, I don't trust that at all. And I don't think that's the way for the law and development field to go ahead. I do think that indicators are very important in defining goals and therefore assessing individual policies, and that you can do that. You can even do that sort of thing in a very specific contextual way. But the moment you start doing these cross-national macroeconomic analyses, I think you're off in cloud cuckoo land. I hope that answers your question.
This may be an impossible question.
This is coming from behind you, David.
Aaron, do you want to come around?
Sure. This may be an impossible question, for which I apologize in advance. I wanted to...
Wow, what's coming now?
I wanted to pick up on your response to the question about human dignity, where you said, no one's really interested in saying that we should not be solving. But I want to sort of take another angle on that. So you were talking about Sen's idea of development as freedom. You might get into a much more subtle and nuanced interpretation of the concept of human dignity when you contend with how Sen might say free markets are essential for the realization of human freedom and dignity. Others might say that those very same free markets might actually reproduce unfreedom in various ways. You could look at, for example, how the consolidation of property rights in East Asia turns communitarian peasants into proletarians as one example. And basically, how do we bridge the ability to reflexively interrogate a concept like human dignity or human freedom in a way that it interacts with the free market at the same time as we are balancing that ability to critically interrogate concepts with usable knowledge, without getting into what Professor Trebilco said, everyone's idea of utopia. And I don't want to press the issue, but how do we do this while preventing ourselves being trapped by the limitations of indicators as a way out of this bind?
Yes, I agree with you completely. It's a problem. That's a lot. That's going to require a certain amount of unpacking because you've kind of put a lot of stuff together. First, I do not think that it is a necessary inference from the concept of human dignity and freedom that you must have universal free markets. I don't believe that. I actually believe in markets as a tool of economic activity, and I wrote an article once about socialist market economies which came out just when they started to get rid of them. They didn't last very long. It was Hungary. So I am a believer in markets, but also a critic of markets. And I don't think that you can derive some policy toward free markets one way or another, how free, what sort of regulation, blah, 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 from the concept of human dignity. If Sen draws that implication, then that's his problem, not mine. Maybe you better ask, so that's my first reaction. Now maybe you better unpack a little bit.
So what I want to unpack is how I appreciate your insistence on the production of usable knowledge as the ultimate point of this inquiry. But basically, just epistemologically, how are we going to get to that usable knowledge while retaining the ability for a kind of reflexive interrogation of our concepts? Well, if we're not going to depend on indicators as the benchmark for its pragmatic implementation.
But I didn't say that. I didn't say we can't use indicators. What I said was, I'm against using indicators and then correlating macro social indicators with legal system numbers and concluding causal relationships. That's my critique of the indicator world. That's part of the critique. The second critique is indicators can be badly or drawn or well done. Doing indicators well and actually measuring what you're trying to measure is a very, very sophisticated game. In many cases, sometimes it's very obvious, as one that Kerry mentioned, right? Girls, schools, not too many variables there. Although I'm sure we could think of some problems there. So I'm in favor of using indicators carefully and thoughtfully to observe and measure certain kinds of activities. I'm just against trying to use them in causal accounts on a macro level. But I could use them in a macro level. I could a micro level, excuse me. I could see using indicators to assess certain policies in particular countries in a contextual way. Absolutely, all in favor of it. Bring it on.
No, I got a big list of people, I'm going to have to move on.
Okay, all right, fine.
Sorry.
So I want to come back to the context question too, and push that a little bit more because that's where all my writing angst comes from. So when we go into the context and we're understanding the political, the social, the historical, and we're putting the economic changes in that context, we're really placing it in we're going down the rabbit hole of interests, right? We're identifying interests that are affected by certain legal change and whether their economic goals are met, which leads us either into the substantive, which takes us to the indicators, which I personally don't have as problematic, but we've got these substantive goals we want to meet for those indicators. But if we can't, we go to the procedural. It seems that we end up back in this procedural recommendation that we, as outsiders, we can't change it. We can identify context. We can show you what's been done here and what's been done there. And we can draw these parallels in the academy. But ultimately, the change has to come from within, and that leads to procedural frameworks. And then the question is what procedures, which brings us back to our long context question of, well, here are some procedures that have been used and maybe they'd apply really well here. And so when we come to this, which always brings me back to this full circle, and I wonder whether you feel stymied by that in any way, that you end up questioning what institutions end up getting placed in order to promote the development that the indicators have brought forward.
Well, I have to ask you a question because I'm not quite sure what you mean by procedure in this context. Could you give me a concrete example?
So the identification of interests or political interests and impacts ultimately leads to the identification of political entities, sub-communities within communities. And that we dealt with generally through the representation of those interests and impartial decision makers, or at the end of the day, perhaps discretionary decision making, that this group will not be addressed. Their interests will not be addressed because societal goals trump them. So those institutional processes that allow for that accountable decision making are the answer in the absence of a substantive answer. maybe you don't think so.
No, I think that in a way I probably agree that that's the way it's going to end up.
But that doesn't bother you because that brings you back full loop. Suddenly we must recommend institutions. And when in the recommending institutions, we must go back through the full loop of the law and context analysis, which brings in the various interests that get represented or not represented in that context.
But I think that's the context. The context is the procedures and the crystallization of some policy through these procedures. You can criticize the procedures, but in the end, you know, the contextual knowledge. I mean, first, we're now talking about the relationship between the academy and decision making in the real world. So what I am envisioning is various ways in which policy is set inside the legal system, outside the legal system, about the legal system, whatever, affecting this, that, or the other thing. What I'm saying is that the academy needs to find ways to inject usable knowledge into those processes, not to come up with an answer to how you should run the energy policy in Brazil or the poverty alleviation program in Sao Paulo. That's not what I think the academy does. The academy feeds into processes of which it can independently be critical. But in the end, that's, you know, the policy is going to get made that way. And what I'm looking for is ways to see that what's injected into those processes from the academy is as useful as possible.
Do we have anything to say about the processes there?
I think that you have to. I think that you have to. And so that can be a real dilemma. That can be a dilemma. If you think the processes are so skewed and so biased in ways that you believe, based on your knowledge and your understanding, will lead to results that are counterproductive for the country, for some distinct interest, you know, you have to say that.
So we're all administrative law scholars.
God help us.
We've got two more on the list. I think, Ed, I should be watching the time, shouldn't I? How am I doing?
Yes. I think you're fine. I mean, that's a little slow. So 28 to 6.
Tiago?
So my question is about context too, in reform projects. So we should look at similar countries when you are working on a reform project. But what's the limit of this approach? I'm asking that because I'm working on a project, the mining reform project that's been discussed in Brazil, and trying to look at similar countries where similar project was developed. But those projects was developed by the World Bank in a not very different way. They are very similar. So it's been difficult in my research to see how it could actually help.
So what's a similar country?
Well, he didn't really ask that. That's a more difficult question. I thought he was going to ask that, and I was going to say, oh, I'll finesse that one. He actually asked a different question, which is, if similar countries, however defined, have all adopted the same policy because they believed in one-size-fits-all, or they got a lot of money for the World Bank, or some combination, probably more the latter than the former, but then what good is it looking at them? Well, one answer is, did it work? Did it work? I mean, if the policy worked, who cares whether it came from the World Bank, the Chinese government, or you know, Chuck Sable? It doesn't matter as long as it works. I'm a pragmatist. So if you look at these countries and the policies achieve whatever goals you want, or you think the Brazilian community wants or needs, or you whatever would recommend, whatever. And you look, I don't know what these countries are you're looking at, but let's just imagine one of them is Mexico, and you look at Mexico and it's all a mess, then you've learned something. You don't have to necessarily find good things when you do this horizontal coordination. You may find, oh, don't do that, what the Mexicans did, what a mess, or the Chinese or whatever. So on the other hand, if it worked, who cares where it came from? So it's still a valuable thing to do. Now, the question really, this is what my class is, how do we know in trying to derive something, whether it's negative or positive, from the experience of another country, whether it's similar enough to us being you, Brazil in this case, so that it's really relevant. And that's the tough one. Is it per capita GDP? Is it you know, historical legal tradition? Is it? And the answer is it's, you know, this is an art that is just, that doesn't really exist. People don't do very much of this in law. It's done in other fields. There are global or the South-South networks in other fields that have, you know, seem to work. There's an inter-American network in social policy that meets regularly academics, and they compare results and they talk about things just exactly like this. Did it work in Chile? Where'd you get the ideas from? You know, what do you think about this? We don't do that in law. Now, you know, in law, because the traditions tend to be, you know, somewhat different, and you know, and there's probably an exaggeration of the difference between the common law and the civil law and all that. A lot of history in that, and there are differences, but I don't think they're as great as some people think. But it is, you know, it has not been a tool of academic work, and particularly in the South, to do this kind of horizontal comparison, and it should be. But it doesn't have to be looking for positive lessons, although that's the most desirable. It's also look for negative stories.
Cassandra, and then
Daniela.
Danielle.
Daniela.
Daniela. Cassandra, Daniela. Lindsay's trying to get in for a second.
Just a quick follow-up to his
question. Cassandra, you're on.
All right. My question is about the relationship and conversation between the academy and the agencies. So I understand that when you say that the contextual approach is definitely preferred over the structural approach, you're talking about the academy, right? And so I'm just wondering how that conversation you see transferring to the agencies. Is it a different goal for the agencies? Is it somewhere in the middle, or is it just for them to take some bit of the extra contextual approach that we look for in the academy?
So imagine you're the World Bank. The World Bank. It's both the world and a bank. And you go down to some country, let's call it Buddha, and they say, what should we do about our legal system? Now, you're the world. Can you say, I don't know, whatever you think works, we don't know what, you know, we want some money, we'll give it to you. It's very difficult for them to do this because they're big bureaucracies and they believe that they have expert knowledge. So built into the bureaucratic structure of development agencies is one size fits all. And then they say, oh, well, it's not really one size fits all, you know, there's variation, but then when you talk to people who talk to them, and I do not talk to agents anymore. I had my last experience with AID 15 years ago and decided I would never get near the place again in life, but that's another story for which we don't have time. So I think that it's one thing for me to say it, it's one thing for academics to say it. It's hard to do because how do you do your academic work if all you say is mush? It's all mush. You know, it's all mush and you have to, it's local knowledge and I have no idea and I can't make any generalizations and I'm going to go down there and I'm going to let the people figure it out and blah, blah, blah. I mean, that's not very good stuff, right? So that's what Ed was, I think Ed was the Ed one. You the one who raised this? Yeah.
Right.
And this is a big problem and I don't think I've solved it, okay? But, and that's for the academy. Now for the agencies, I think all you got to do is keep chipping away at their confidence and coming up with counterexamples and showing that there are alternatives, that it isn't all, you know. But you have to assume you're going to encounter resistance to too much variation, not because they're bad people, not because they have some evil project that they're trying to foist on the world, but because when you run a big bureaucracy that deals with 100 countries, and you want to have some sense of authority and knowledge about what you're doing, it's hard to just sit back and say, tell me, you know, like some psychiatrist saying, tell me about your legal problems and your mother.
Daniela.
Well, my question is exactly on this point. You know, ultimately, I come from the South, and I come from Brazil, and development is not something that is ephemeral. It is very much tangible. You want very specific things. You want sewage. You want, lack of. You want people to not be hungry. Is it really necessary to have a field of law and development, or is it merely just? Is it merely just to look at the practical issues that developing countries have, and therefore practical answers need to be had? Is it necessary really to have a theory and a field and an entire framework to just fix these problems?
Yes. Would you like me to elaborate?
Yes, please. Yes, please.
I think it's a terrific question.
It's a very good question. You must be a very good lawyer, because you've so loaded the question that it's hard for me to answer. If we have these real problems and people not having any sewage or starving, why do we need Max Weber? Well, I mean, it's kind of hard to answer. But if you think that some systematic knowledge about the legal system in your country and the way it operates and the way it does or doesn't further the goal of better sewage, if you think that that knowledge is useful, whether it draws on Max Weber or Chuck Sable or Mariana Prado or 3 other people down the street, then it's worth having. And I think that you can learn, because I think that one of the things that I said was that context-dependent, usable knowledge has to be theoretically formulated. If you're a lawyer and you know that you know how to read rules, you know how to read cases, you know how to say it's the law that, but remember the as leis que não pegou, the laws that don't take. The whole question of how law really does change behavior or doesn't change behavior, how it fits into people's consciousness so that things that are not even being affected by the existence of a particular law or some enforcement mechanism is shaping the way people think and interact on a daily basis. If you believe all of those things, then you need knowledge that goes to, in order to understand what's happening and figure out what the legal system can do in the area of poverty or sewage or mining, for iron ore. You need that kind of knowledge that goes beyond just what the legal rules are, because they're not necessarily having any effect, or they may be having the wrong effect, or they may be working. You don't know. So my case for law and development is it's really just a case for law and economic, socio-legal knowledge, sort of interdisciplinary knowledge about the operation of the legal system in a developing country, with some particular emphasis on certain objectives and certain histories that are particular to those countries or to some group of countries. That's all. And so if it's useful that legal academia engages in empirically based but theoretically informed knowledge about the legal system in Canada, it's useful in Brazil. That's my case.
Lindsay, you got a last very sharp comment.
Well, I was going to say that one thing that occurred to me when we were talking about how the agency's persistence in this one-size-fits-all model in some ways provides almost the opposite of a randomized control trial for us academics, because if we have the same policy, but we're putting, or similar policy, so whether it's your sewage improvement project or inputs into basic education or whatever it might be, if we're all following the same model, but we're seeing different outcomes, then there seems to be an opportunity there for academics to try and unpack, if we put the same policy in, is it that it didn't take, is it that it was corrupted by certain political forces? So as I say, I think in some ways we can capitalize on the sort of narrow-mindedness of the agencies to try and understand what the next, law and development 3.0 should be based on.
I think that's a great idea. And Law and Development 3.0, I'll just close then, because I think this, you want to bring it to an end.
Yeah.
So my view about Law and Development 3.0 is the big difference is that it's not one size fits all. It's not one thing, except in the extent that it's the pursuit of usable knowledge that will eventually make a difference to people in developing countries. And whatever makes that happen, I'm fulfilled.
And you'll come back in 10 years and talk about Law and Development 3.0?
Maybe 15.
Thank you very much.